Hey everyone, today we'll be playing Legal Arena. So, we have the dashboard right here, and I already have a bunch of cases started because I'm the developer and I've been testing most of it all this while. Today I'm going to actually play the game and show you what it's like. So, first, we're going to scroll down and look for the case library. Here we have a bunch of different uh, categories. Let's see what we can find. Let's find an interesting one. For example, here there is a case called the deposit fight. Okay, let's start this one by clicking enter. It's loading. Okay, so we are at the client intake screen, and this is where you first talk to your client and find out what they want. So right now we are so once we pick the case, we are randomly selected between the plaintiff side and the defendant side. And right now we are representing the defendant side. So that's why we have this is our client Harborview Properties LLC, and this is the brief with which they came to us. Um, it looks like, think of this as an email that they initially sent you asking for your help. So here Harborview says, from my side, this was a routine move out that recast as us grabbing a deposit for no reason, and that's not what happened. When I think back to the turnover, I remember carpet cleaning, wall touch up, a damaged blind, and extra cleanup making it onto the accounting because the unit didn't look ready to hand straight to the next tenant. A file may not be pristine, but I do not believe those charges were invented. So basically, they're saying that the client sued them for the deposit money, which the tenant sued them for the deposit money, which Harborview allegedly held back. So basically, this is just a rant. People come walking in. You just have to sit them down and calm them down, and ask questions one after the other. So I'm just gonna ask them, give me a timeline of events. What exactly happened? Well, this will just generally give me the whole story. So Maya rented a one-bedroom for from us for about a year under a standard lease and paid a security deposit at move-in. During the tenancy, there were complaints about a kitchen sink leak and a bedroom window latch. And from our side, those were treated as routine maintenance items with at least some response. Even if I can't swear every work order was perfectly logged. Near the end of the lease, she gave notice, moved out, and turned in the keys. After that, we did a move out inspection, and our staff concluded the unit needed carpet cleaning, wall touch up, a repair or replacement for broken blind, and extra cleanup for trash removal before turnover. Based on that, we issued a final deposit accounting that, as I remember it, kept most of the deposit and itemized those deductions. After that, the dispute became her position that the charges were improper and that the earlier maintenance issue should excuse or explain them, which I do not agree with. Okay, so I'm just gonna go ahead and ask some standard questions here. Uh, did you send Maya the itemized breakdown of the deductions? Yes, I believe we sent her the final itemized deposit accounting on time. What was the deposit and how much of it was withheld? The security deposit was 1,500, and we withheld most of it, roughly $1,200. Cool. Okay. Now this is where we have to ask some really good questions to help your client out. Let's see. Were there any move in or move out checkout lists, checklists? So right now she's the apartment manager saying yes, but then we should also get the exact stuff. What specific amounts does that record show? Let me ask that question. And by the way, as we ask these questions, this is what is called a fact sheet. So the fact sheet is what you refer to in court, and the fact sheet has multiple sections: theory, timeline, proof, risks, disputed, records, gaps, relief. And I'll show you what each of them does. Theory basically just explains what your argument should be and why you're explaining why your side should win. Timeline, it just describes the timeline of events. Proof, this is the facts that support your side. And here the facts that emerged are tenancy included sink leak and window latch complaints. Deposit deductions were itemized in final accounting. Accounting list carpet walls, blind cleanup deduction. So these things support the fact that the deposit should be withheld. Risks, weak points the judge or the other side may use against you. Work order logging may not be complete, and deposit withholding amount stated as recollection. I don't know what that means, but okay. What are some disputed facts? These are facts that both you and the other side may disagree on. And right now, this is whether maintenance issues excuse or explain deductions. This is true or false. We don't know that. The court is going to decide for us. We haven't found any facts, any corroborated facts yet. That's what we're doing right now. But before that, we should also ask what it is that uh, Harborview wants from the court. What relief are you expecting from court right now? I'm asking the court to deny her claim for return of the withheld deposit or at least reduce it to the extent the deductions are upheld. Okay, cool. Um, I'm gonna ask them, is it can you prove that it's beyond wear and tear, those damages? Because if it's wear and tear, it's if it's like regular wear and tear, then they don't have any right to withhold that deposit, right? Um, why do you think the amount you deducted for repairs and cleaning are beyond ordinary wear and tear? Now, I want to give you guys a disclaimer. I'm not a lawyer, okay, but I do enjoy watching legal shows. Um, Suits is one of them which I started with. But I've also watched a few others, Hindi ones. Okay, now how viewers responded. Because from our inspection, the carpet needed cleaning for staining, the walls needed touch up for marks, and small holes of patch for points. There was a damaged blind, and there was an extra cleanup for thrash removal beyond normal turnover. Okay, so they couldn't return the apartment as is, but that's not an argument, right? But since I'm a lawyer representing this side, I have to find a way to make this win. Let's see. What else can I ask? What else can I ask? What amount is being claimed? Let's find that out first because maybe Maya is not claiming all of that $1,200. My recollection is that the security deposit was 1,500 and the withheld. So she's asking for the entire security deposit, Maya. Hmm. Do you have photos of the condition of the apartment that suggest that the damage caused was beyond ordinary wear and tear? This alone will probably give me a corroborated fact, which is what is here right now. Currently unpopulated. Yes, there are move out photos. Awesome. When was the photo or the screenshot taken? Describe what the photo or screenshot shows. Let's see. It shows the move out condition of the unit, including the carpet, wall marks, or small holes, damaged blind, and the areas that needed extra cleanup. Awesome. Um, do you think we have enough to defend ourselves? Let's see. Win chance. We have 63% win chance. Harborview has some corroboration and itemized deposit accounting reportedly sent on time plus move out photos supporting specific deductions. Awesome. Main dispute favors neither side cleanly because the ordinary wear versus damage is unresolved. But the tenant's challenge appears thinner without exact contrary records in this file. Um, Risk remains because key amounts are only recollection and exact line item costs are missing, which could reduce or trim the uphill deductions rather than defeat the claim entirely. Okay, fine. Let me see if they have invoices for the work. Do you have invoices for the work done? For wall repainting, repairs, holes, lines, and the extra cleanup. You have in high invoices of bills. Yes, I believe we have some vendor charges or invoices tied to that. Read me the records, date, and exact wording, and then we'll ask what specific amounts. Let me paste this, copy this first, and let me ask that. Okay, he doesn't have if she doesn't have the file with her. Okay, let's ask the next question. What specific amounts or details does that record show? From memory, it shows deductions for carpet cleaning, wall touch-up, or painting. Okay, she's just repeating the deduction letter, but I guess that should be good enough because we have invoices and we have move-out photos. Okay, I think we will move this to court then because we already have a decent chance, 62% chance to win. Let's see what happens in court. Okay, so the counsel for Maya Torres has given an opening statement, which is that, Your Honor, this is a straightforward security deposit case. Maya Torres rented the unit for about a year, gave notice, cleaned the apartment, removed her belongings, and returned the keys. After that, Harborview kept most of her deposit, roughly 1,200 out of 1,500, based on deductions for carpets, walls, blinds, and cleanups. Mrs. Torres challenges those deductions because they overstate what was actually left behind, blur the line between ordinary wear and chargeable damage, and shift routine turnover costs onto a departing tenant. The court will hear that Miss Torres believed The apartment was left reasonably clean and in decent condition when she moved out. The court will also hear, okay, why are these texts here? Those unresolved maintenance issues. Under the rules that govern deposit disputes, withholding money requires more than broad labels. It requires detailed, fair notice, and a connection between each deduction and actual tenant caused damage, rather than normal use. Where the claim charges are vague, inflated, or tied to ordinary wear or routine cleaning, the money should be returned at the close. Money should be returned at the close of this case. Ms. Torres will ask the court to order return of the improperly withheld portion of a security deposit, along with any allowable cost tied to having to bring this dispute before the court. Okay, so we are going to tell them that first of all we have the photos and we first of all we have the bills, but we don't want to show all of those right away. We just have to tell the court that it's not overstated and we have the evidence. Let me think. What do you think should be done here? Okay, I'm going to tell the judge, Your Honor, my client has documented the repairs via invoices done via invoices, the work done on the apartment. They were The tenant left the apartment with holes in the wall, a broken blind, and the holes in the wall, broken blind, and let's see, broken blind, and what else was there? And uh, dirty and filth in the apartment, no, and garbage in the apartment. Those cannot be dismissed as treated as regular wear and tear. We also have photos to corroborate this fact. Besides, the plaintiff is trying to build a case around procedure, but procedure only exists to keep documentation airtight in case a dispute arises and needs to be taken into court. This airtight procedure is not feasible for every tenant, every landlord in this country. That said, we did. Okay, now this is the part where we defend. We tell them what due diligence we did. Okay, so I'm going to look at corroborated facts. We have move out photos after cleaning, and we have invoices or receipts supporting each deduction. But we're also going to look at supporting facts, which is deposit. We have these green facts and the yellow facts. Green facts are the strongest ones. Deposit deductions were itemized in final accounting. Accounting listed all these. Okay. I don't know what I'll do with these supporting facts, but let me continue building the argument, which is that said, we did do our due diligence and documented the expenses along with photos and invoices. Um, let's see. Let's see where it goes. Presenting. So, okay, looks like our argument was pretty bad. The court views this as an effective rebuttal round for the tenant. The landlord's argument overreached by asserting invoices, photos, and even garbage without visible record support. I thought the photos had garbage. Cool, whatever. While minimizing procedure in a category where itemization and actual cost support actually matter directly. Okay. Uh, cool. What did the opponent say now? Your Honor, counsel asks the court to rely on photos and invoices, but none have been identified with any specificity here. And the details that matter in a deposit case are still missing. What exact amount was charged for each item and for what actual cost? Under the rules governing deposit deductions, broad references to repairs are not enough to justify keeping roughly 1200 out of 1500 deposit. And even taking council description at face value, holes in the wall, broken blind, and generalized cleanup not automatically established that most of the deposit was properly withheld. The court still has to separate ordinary wear and routine turnover from actual tenant caused damage. And this record does not tie the challenge deductions to documented itemized chargeable losses. Okay, so we are basically getting screwed. What do we do here? Hmm, let's see. We can look at what is the missing evidence and gaps. Exact line item deduction. Okay, so we are kind of weak on documentation. But having said that, we should also we are also entitled to withhold a deposit in case the tenant was badly behaved. So right now our challenge is to I think tell the judge that this damage was beyond ordinary repair. So I have to tell them that the photos themselves show broken blinds, holes in the wall, and cleaning that required cleaning that required cleaning that was more than what could have otherwise happened from normal wear and tear. Yeah, the according to the lease agreement, the tenant is obligated to clean the apartment before vacating, which which clearly wasn't good enough to be left as is for the next tenant. So basically, I'm just saying that she did a poor job of cleaning the apartment, and it wasn't good enough for the next tenant. Plus the repairs for blinds and all that. Uh, I should also mention that besides the blinds could not have the blinds could not have broken by normal wear and tear, and as shown in the photos. Let's see if this works. We just made a slight amount of progress. Let's see. The court views this as another tenant favorable exchange. The landlord improved by narrowing. to blinds, holes, and cleaning, but Rule 11 remains a central problem. The record still lacks specific cost support and quantified line items for keeping most of the deposit, and Rule 9 cautions against treating generalized cleaning and minor condition issues as fully chargeable damage without more. I thought we had invoices. We have invoices or receive supporting. So I'm going to tell the judge that we do have invoices or receipt supporting each deduction. Let's see if this works. Okay, the opposing counsel prevailed. Yeah, I didn't cite a lot of laws, so that's the problem. Opposing counsel prevailed. The court rules for the other side on deposit dispute. You did surface that deductions were itemized in some form, and that inspection notes reference blinds, laws marks, holes, staining, and cleanup. But in security deposit case, Rule 11 requires more than a general statement that receipts or invoices exist. The landlord must justify deductions with itemization, actual costs, or specific condition evidence tied to the amount withheld. Rule 9 also requires the court to separate ordinary wear and routine turnover from chargeable damage. Here, the other side proved the deposit was withheld and challenged the deduction theory, while your side did not place concrete line item amounts or actual cost support into the visible record for keeping about $1,200. On this record, the withholding is not sufficiently justified, so the challenged portion of the deposit must be returned, subject to any minor support deduction not established here with usable detail. Key issue: you did not tie the withheld amount to specific line items. Yeah, yeah, I should have dove more into detail. What did help my side? You established that deductions were asserted after the move out inspection. You identified specific condition categories into the other side says were at issue. You gave the court a theory that at least some conditions might support limited deductions in if property if properly documented. What weakened your side? You did not tie withheld amount to specific line items or actual costs. You did not put the contents of any invoice, receipt, or photo into the record with usable detail. You did not narrow your requested allowance to a supported partial amount. Anyway, so this is how this case panned out. Um, if you want to play the game further, uh, sign up and play it at legalarena.app. This is what the website looks like. Happy lawyering.